The U.S. Supreme Court sends the decision on presidential immunity back to the lower court. A look at what this means for former President Trump and the election interference case right here in Georgia. The Supreme Court issuing its ruling in a landmark case that could have an impact on November's election. Thanks so much for joining us. For Fox 5 News at 4, I'm Christine Spiro. The justices said former presidents, including Donald Trump, enjoy a certain amount of immunity from prosecution. We have team coverage on this historic decision. Fox 5's Rob D'Arienzo has a look at what this means for the former president and the Georgia election case. We begin first with Fox 5 anchor Russ Spencer live in studio here with more on the court's ruling. Russ.
Donald Trump saying this is a big victory for him and for democracy. In a 6-3 ruling along the political divide of the court, the justices decided that presidents have immunity for official acts carried out in office, but do not have immunity for unofficial ones. The decision sends former President Trump's election interference case back to a lower court to decide whether his actions.
What's good, people? Dr. John Podcast is back again. Judge Amit Mehta rejected Trump's broad claim of presidential immunity, using Trump's own words as evidence in a ruling that fundamentally reshapes the January 6th cases. The decision strips away the legal shield Trump has relied on for years, with major implications for his civil and criminal liability moving forward. For years, Trump has been hiding behind this one simple, elegant, and surprisingly effective legal theory. I'm the president. Everything I do is official. You can't touch me. That's basically been his entire legal strategy since the Capitol attack happened. And honestly, it actually worked for a while. The Supreme Court even backed him up on it back in 2024, giving presidents broad immunity for official acts. So Trump's team ran with that ball as far as they could take it. They said, look, everything I did that day, the speech, the phone calls, all of it, that was me doing my job as president. Untouchable, case closed, go home everybody.
Or official or unofficial. It also delays his trial in Washington ahead of the November election, meaning that if he wins, he can tell his Justice Department to drop the cases. Now, prosecutors have accused the former president of illegally scheming to cling to power after he lost to President Biden. The ruling amounts to a major victory for the presumptive Republican presidential nominee, whose legal strategy has focused on delaying the proceedings. The former president reacted to the ruling, telling Fox News Digital, "This is a, quote, big win for our Constitution and for democracy." The Biden-Harris campaign also weighed in, saying this does not change the facts of what happened on January 6th. So, was the call to Brad Raffensperger on January 2nd, asking for 11,780 votes, an official act or an unofficial one? They're going to disagree about that, and we'll see what happens in court.
Yeah, there was no decision on what is official and what is unofficial by the Supreme Court, right? So like you said, it'll still be debated. Russ, thanks so much. And big questions about how today's landmark Supreme Court ruling over presidential immunity.
That was the pitch. And for a long time, it actually seemed to be working, at least well enough to keep this specific case stuck in legal limbo for years without ever reaching an actual trial. But here's the thing about legal shields. They only work if the person holding them is actually standing behind the right kind of conduct. And Judge Mehta just looked at that shield, examined it carefully, and found a massive gaping hole right in the middle. On March 31st, 2026, Judge Mehta ruled that Trump's speech at the Ellipse, the Stop the Steal rally right before the Capitol got stormed, was not a protected presidential act, not official business. Mehta said Trump was acting as what he called an office seeker that day, not an office holder, meaning he wasn't doing president stuff. He was doing help me stay in power stuff. And there's a legal difference, a huge one, because if it's not an official act, immunity doesn't cover it. That means the lawsuits against him can keep moving forward toward trial, with depositions, with discovery, with Trump potentially having to answer questions under oath about January 6th.
Will impact the former president's prosecution here in Georgia. Let's go to Fox 5's Rob D'Arienzo with that angle of the story and the fallout this has played out in Fulton County. Rob, what does this mean for the former president's RICO case?
Hey there, Christine. Well, some legal scholars tell me that this will change, but not completely derail the former president's massive RICO indictment in the courthouse here behind me. At the core of this, as Russ just mentioned just a few moments ago, is whether or not the former president was acting in his official scope of duties when he called Secretary of State Brad Raffensperger to try to overturn the results here in Georgia.
You're certainly at least going to get arguments about that, about whether there is immunity in the Georgia case.
Emory Law School professor Jonathan Nash spent the day combing through the Supreme Court's landmark decision Monday that former presidents are immune from the law if they're acting in an official capacity.
The court says there are certain things that lie within the core sphere of presidential authority.
But Professor Nash says the court did not offer any legal immunity for former President Trump's unofficial acts.
Setting up a scheme of fake electors is not.
This is genuinely wild when you stop and think about it. The entire foundation of Trump's defense strategy in multiple cases has been this immunity argument. It's been the wall he's hidden behind, the moat he's relied on to keep legal challenges at bay. And now a federal judge has said in writing, on the record, that wall has a door, that moat has a bridge, and the plaintiffs in this case can now walk right through it. But it's not just the speech. Meta also ruled that Trump's infamous phone call to Georgia Secretary of State, the one where he pushed for 11,000 more votes, that also isn't protected. The judge said, and I'm paraphrasing here, that's not a president doing his job. That's a guy trying to overturn an election he lost. Big difference. Huge difference, actually, legally speaking. Now, it wasn't a total wipeout for Trump. Meta did say some of his other actions that day, like remarks he made in the Rose Garden and his calls with Justice Department officials. Those might still count as official acts, and Trump can still argue immunity again once the case actually goes to trial. So this isn't some magic guilty stamp.
Big questions about how today's landmark Supreme Court ruling over presidential immunity will impact the former president's prosecution here in Georgia. Let's go to Fox 5's Rob Marienzo with that angle of the story and the fallout this has played out in Fulton County. Rob, what does this mean for the former president's RICO case?
Hey there, Christine. Well, some legal scholars tell me that this will change, but not completely derail the former president's massive RICO indictment in the courthouse here behind me. At the core of this, as Russ just mentioned just a few moments ago, is whether or not the former president was acting in his official scope of duties when he called Secretary of State Brad Raffensperger to try to overturn the results here in Georgia.
You're certainly at least going to get arguments about that, about whether there is immunity in the Georgia case.
Emory Law School professor Jonathan Nash spent the day combing through the Supreme Court's landmark decision Monday that former presidents are immune from the law if they're acting in an official capacity.
The court says there are certain things that lie within the core.
It's not that simple. But here's the headline that actually matters. His big blanket, everything is protected defense, just got a giant hole blown through it. And that hole leads straight toward a real trial with real consequences for real people who were actually there that day. The case is called Lee versus Trump. It's brought by a group of Capitol Police officers and members of Congress who were there that day. People who lived through the actual attack were suing Trump personally for the harm they say he caused. Some of these officers were beaten, crushed against doorways, sprayed with chemical irritants, dragged into the crowd by rioters. This isn't some abstract legal theory case. These are real people describing real trauma from a real day, and for years they've been stuck waiting to even find out if their case will be allowed to move forward at all. This ruling means their case doesn't get thrown out. It keeps going toward a jury, toward potential damages, toward Trump possibly having to sit for a deposition about the worst day of his presidency.
A sphere of presidential authority.
But Professor Nash says the court did not offer any legal immunity for former President Trump's unofficial acts.
Setting up a scheme of fake electors is not something that the Constitution directly calls for.
And now the fate of former President Trump's legal troubles in Georgia, federally and elsewhere, hinges on what official means. Fulton County Superior Court Judge Scott McAfee must go through each of the former president's 10 alleged felonies and figure out if any are now void. That includes if Mr. Trump's now infamous phone call with Secretary of State Brad Raffensperger pressuring him to flip the results was part of his presidential duties.
But the special counsel can't point to the president's motive. That's not something that can come into play. The action is either going to be sort of official or not official.
Professor Nash says that same metric will come into play in Georgia as well as in his federal cases. But the former president's RICO indictment in Fulton County has been at a standstill as the courts decide whether District Attorney Fani Willis should be off the case following her romantic relationship with Special Prosecutor Nathan Wade.
Answering questions under oath on the record about exactly what he said and did and why. And of course, how did Trump respond to all this? Did he calmly accept the ruling? Maybe issue a measured statement about respecting the judicial process? Yeah, right. His team called it a meritless Democrat hoax. Trump himself has been out there for months calling judges who rule against him wacky, crooked, accusing courts of being weaponized, even claiming some judges have something he calls Trump derangement syndrome. That's not a real diagnosis. That's just a guy mad that the legal system doesn't always go his way. And honestly, this response has become so predictable at this point that you could probably write it yourself before he even says it. Judge rules against him. Judge gets attacked personally. Ruling gets called political. Rinse and repeat. So buckle up, because this is a much bigger story than one ruling from one judge. This is about Trump's entire legal shield starting to crack, right as another huge loss just hit him too over his emergency tariffs. Two completely different courts, two completely different areas of law, landing on a surprisingly similar message about the actual limits of presidential power. And that's where things get really interesting, because what we're witnessing isn't just one case moving forward. It's a broader judicial pushback against the idea that the presidency comes with a blank check. Let's slow down for a second, because a lot of the viral clips flying around are making this sound way simpler than it actually is. Some people are acting like Trump just got convicted of something he didn't. This is a civil case, not a criminal one. Nobody's going to prison over this ruling, but other people are downplaying it too much, acting like this is just some minor procedural thing that doesn't matter, some paperwork shuffle that changes nothing. And that's wrong too. So let's actually understand what happened here, because the details matter a lot. And honestly, the actual legal reasoning is a lot more interesting than either Extreme Take gives it credit for. First, let's back up to 2024, because you need this context to understand any of this. The Supreme Court ruled that presidents have pretty broad immunity for official acts done while in office. Not unlimited, but broad. Core constitutional duties like commanding the military or issuing pardons get absolute immunity, meaning there's basically no way around it. Other official acts get what's called presumptive immunity, meaning you're probably protected unless there's a really strong reason otherwise. But here's the key part everybody forgets. Private personal conduct, stuff that's not actually part of the job, that gets zero immunity. None. That's always been the rule. Even under this same Supreme Court decision that a lot of people thought gave Trump a total blank check. So, the entire fight since then has been about which bucket different actions fall into. Was the Ellipse speech Trump doing his job as president, or was it Trump, the candidate, trying to stay in power by any means necessary? That's the exact question Judge Mehta had to answer. And he didn't just wave his hand and decide it emotionally. He went through it in serious, methodical detail. He pointed out that the White House didn't organize the rally. No taxpayer money was used to put it on. The White House didn't promote the speech beforehand on its official channels, and it didn't publish the remarks afterward either. In other words, this wasn't a presidential event dressed up as a rally. It was a campaign-style rally dressed up to look official. But functionally, it wasn't the government doing government things. It was Trump doing political things, using the trappings of the presidency, but not actually exercising presidential duties. And here's a detail that a lot of the viral clips skip completely, and it's honestly one of the more important parts of the whole ruling. Mehta didn't just rule on immunity, he also said Trump's actual words at that rally could plausibly count as incitement, meaning they're not even fully protected by the First Amendment in the way Trump's team argued for years. That's a separate and honestly even bigger deal legally, because it means the case isn't just about who technically gets sued and who doesn't. It's about whether what Trump actually said that day crossed a real specific legal line that courts have recognized for decades, going back to older Supreme Court cases about what kind of speech loses First Amendment protection when it's aimed at producing immediate violence or lawless action. Now let's talk about the Georgia call, because this part is honestly kind of wild when you read the actual quote straight from the transcript. Trump told Georgia's Secretary of State, and I'm not making this up, that he only needed 11,000 votes and to give him a break because they already had that many votes in spades. Mehta looked at that exact language and said, look, that's not a president doing official government business. That's a guy who lost an election trying to talk a state official into finding him enough votes to flip the result in his favor. Mehta's exact words were something like this: these are the words of an office seeker, not an incumbent president acting in his official capacity. That's a pretty blunt way for a federal judge to put something on the record in writing in an official court opinion that's now part of the public record forever. But here's the twist that most people online are completely missing. And it's honestly the more interesting and more nuanced part of the entire story. Meta didn't rule against Trump on everything he did that day. He actually said a call Trump made to Michigan officials might still be protected by immunity, depending on how the facts shake out later. So this isn't some blanket Trump loses everything moment, no matter how the headlines are framing it. It's much more surgical than that. The judge went through specific actions one at a time, methodically, and basically drew a map. This action not protected. That action may be protected. We'll see. This other one's still up for debate once we get to trial. That's actually how the law is supposed to work. Carefully, case by case, weighing specific facts against specific legal standards, not some sweeping Trump bad case closed moment that a lot of these dramatic headlines are trying to sell you. And here's another thing people get wrong constantly in the comment sections. This ruling doesn't mean Trump automatically loses the lawsuit or that a jury has already decided anything. It means the lawsuit gets to continue existing and moving forward. That's a huge difference, and it's worth repeating clearly. What happens next is discovery, depositions, evidence gathering, all that grinding, unglamorous legal process stuff that takes years, not weeks, and definitely not overnight like some of these clickbait titles are implying. Legal reporters who cover this stuff for a living have already said this could drag on for the rest of Trump's term. Honestly, given how many appeals are already built into the process at every single stage. So if you're expecting some dramatic conviction moment or a viral courtroom meltdown next week, that's just not how civil litigation actually works in the real world. This is a marathon, not a sprint. And anyone telling you otherwise is selling you a headline, not the actual legal reality. Now let's zoom out for a second because this ruling didn't happen in a vacuum, completely isolated from everything else going on right now. It landed right around the same time the Supreme Court struck down Trump's emergency tariffs in a totally separate case on a completely different legal issue. Different judges, different courts, completely different areas of law. Tariffs versus January 6th immunity. But there's a real pattern connecting them. If you step back and look at the bigger picture, courts have been slowly, carefully, methodically chipping away at the idea that Trump gets some kind of blank check just because he happens to be president. The tariff ruling said, hey, you can't just declare an emergency and tax the entire planet without Congress signing off on it first. The meta ruling says, hey, you can't just call something an official act because you happen to be president at the time you did it. Both rulings are really about the exact same underlying question at their core. Where exactly do the limits of presidential power actually sit in practice, not just in theory? And in both cases, completely independent of each other, the answer coming back from the courts has been remarkably consistent. The limits are real and they're tighter than Trump's team has been arguing in court for years. That's honestly the bigger story here. Way bigger than any single ruling taken on its own. It's not really about Trump personally, even though obviously he's the one at the center of both these cases. It's about how much power any president from either party gets to claim just by virtue of holding the office itself. And right now, courts across very different areas of law, trade policy on one side, personal civil liability on the other side, are landing on a pretty consistent, pretty clear message. The office doesn't shield everything a person does while sitting in it. Not even close, and definitely not automatically just because someone claims it does. And can we talk about how Trump's been reacting to all this? Because it's honestly become a very predictable pattern at this point. Almost like a script he runs every single time. Every single time a court rules against him, the response is basically the same playbook, word for word in spirit, if not in exact phrasing. Call the judge biased. Call the case a hoax. Claim some kind of syndrome or conspiracy is driving the decision. It doesn't matter if the judge was appointed by a Republican or a Democrat. Doesn't matter if it's a tariff case or a January 6th case. The response script barely changes from one situation to the next, which, look, that's his right to say whatever he wants publicly. Freedom of speech goes both ways here, but it does raise a real serious question worth actually sitting with for a second. Are these attacks on judges just venting frustration in the moment, or are they part of a longer, more deliberate effort to slowly delegitimize the entire judicial branch in the eyes of millions of his supporters? That's worth thinking about carefully, because it's a bigger and longer-lasting issue than any single angry statement from a campaign spokesperson. So, here's the honest, unglamorous truth of it. Without the hype and without the dramatic music, this is a real serious legal setback for Trump. No question about that. It removes a major defense he's leaned on for years in multiple different cases. But it's not the dramatic instant collapse the wildest headlines are trying to sell you. It's a slow, grinding, methodical legal process where courts keep drawing narrower and narrower lines around what actually counts as a official versus what counts as personal conduct. And that process is going to keep playing out for a long time, probably years, with plenty of appeals and setbacks and delays along the way for both sides. Let's break down exactly what it all actually means going forward in practical terms. A few main things to understand, then let's talk about what's coming next and what you should actually be watching for. First, and most importantly, Trump's biggest legal shield just got a hole punched through it. And that matters more than people realize. For years, the strategy has been simple and consistent. Claim everything is an official act. Claim immunity across the board. Get the case dismissed before it ever reaches a jury or a courtroom. That strategy just took a serious documented hit. Judge Mehta specifically ruled that the Ellipse speech and the Georgia call don't qualify for that kind of blanket protection. That means the lawsuit brought by Capitol police officers and members of Congress gets to keep moving forward toward actual discovery and potentially an eventual trial in front of a jury. That's a genuinely big deal, because for years, this exact kind of case has been stuck in legal limbo, while immunity questions got sorted out at the appellate level. Now, at least part of it is finally actually moving forward again. Second thing to understand, this is not the end of the road here. Not even close to it. Trump's legal team can still appeal this specific ruling, and they almost certainly will given the stakes involved. They can still argue immunity again once the case actually goes to trial, since Mehta explicitly left that door open. Mehta himself said, this isn't a final pronouncement on immunity for every single action Trump took that day, which is an important qualifier that a lot of coverage is glossing right over. So don't expect this whole thing to wrap up quickly or cleanly. Legal experts who cover this stuff professionally are already predicting this could drag on for years, possibly for the rest of Trump's entire term in office. That's just how civil litigation against a sitting or former president tends to work in practice. It's slow, it's expensive for everyone involved, and it's full of appeals at every single stage of the process. Third thing to understand, this connects to a much bigger pattern of courts drawing firmer lines around presidential power in general, not just in this one case. This isn't happening in isolation off on its own island. Around the same time, the Supreme Court struck down Trump's emergency tariff powers in a completely different case, saying flatly that he can't just declare an emergency and tax the world without Congress signing off first. Different legal issue entirely, but the same underlying theme running through both. Courts are increasingly willing to say clearly, being president doesn't mean everything you do while in office is automatically protected or automatically legal. No questions asked. That's a meaningful shift in how these things are being decided, and it's one that will matter long after Trump leaves office too, because it sets real precedent for every future president from either party who tries something similar down the road. Fourth thing to consider, Trump's response to all of this tells you a lot about the bigger political fight happening underneath the surface here. Instead of engaging seriously with the actual legal arguments in these rulings, Trump and his team have gone straight to attacking the judges personally over and over again, calling them biased, calling the cases hoaxes, throwing around terms like weaponized courts, and claiming judges have some kind of derangement syndrome affecting their judgment. That's not really a legal strategy in any traditional sense. That's a political and public relations strategy clearly aimed at his supporters rather than at the actual judges deciding these cases on the merits. And it raises a real uncomfortable question worth sitting with. What happens to public trust in the entire judicial system when the President of the United States spends years telling millions of people that courts ruling against him are inherently corrupt or fake, regardless of the actual legal reasoning involved? That's a much bigger and longer-lasting issue than any single lawsuit, no matter how significant that lawsuit is on its own. So, who actually benefits here in practical terms? And what should you be watching for as this all continues to unfold? Short term, it's the plaintiffs, the Capitol police officers, and lawmakers who've been fighting for years just to get their case in front of an actual jury of their peers. They finally get to move forward after years of waiting. Longer term, this is really about precedent, about how future courts and future presidents from either party understand the actual practical limits of executive power going forward. Watch closely for appeals on this specific ruling because Trump's team is almost certainly going to challenge it at the appellate level. Watch for how long discovery actually takes because that process alone could stretch on for a very long time, involving thousands of documents and multiple depositions. And watch closely for whether Trump himself eventually gets deposed under oath, because if that actually happens, that's a genuinely historic moment. A sitting or former president answering detailed specific questions under oath about January 6th on the record with real legal consequences attached to his answers. So, was this the instant dramatic collapse the loudest headlines are trying to sell you? Not exactly. And anyone telling you otherwise is oversimplifying a genuinely complex legal situation. But is it a real serious, meaningful legal setback that chips away at one of Trump's central defenses in a case that's been dragging on for years? Yeah, absolutely. No real question about that part. It's not an ending, and it was never going to be one single ruling that ends anything this complicated. It's the beginning of a much longer legal fight that's going to keep unfolding. Court date after court date, appeal after appeal, for a long time still to come. The reality is that what we're witnessing is a slow-motion legal reckoning. Courts don't move fast. They don't deliver dramatic verdicts overnight, but they do move methodically and inexorably toward conclusions that can have enormous consequences. And this ruling is a significant step on that journey. It tells us that the immunity defense, the one that's been so effective at stalling and delaying, is not absolute. It has limits, and those limits are real enough that a federal judge was willing to say so in writing on the record, with Trump's own words as the primary evidence. For the Capitol Police officers and members of Congress who brought this case, this ruling means something profoundly personal. It means their day in court might finally come. It means the legal system might finally give them a chance to tell their story to a jury and to hold accountable the person they believe is responsible for what happened to them. That's not nothing. That's everything for people who've been waiting years just to have their case heard. For Trump, this ruling represents a genuine threat. Not an immediate conviction, not a prison sentence, but a door opening to a process that could be deeply damaging. Discovery could reveal documents and communications that have never seen the light of day. Depositions could force him to answer questions he's been avoiding for years, and ultimately a jury could decide that he is personally liable for the harm caused on January 6th. That's a long way off, but it's now a real possibility in a way it wasn't before this ruling landed. All right, that's it for this one, but trust me, this isn't over, not even a little bit, and there's a lot more still to play out here. The legal battles will continue, the appeals will be filed, the arguments will be made, and through it all, the fundamental question remains the same. What are the actual limits of presidential power when a president decides to use that power not for the country's benefit, but for his own? That question is now before the courts, and the answer is starting to take shape in rulings like this one. We'll be watching every step of the way.